Hey, it's Chad Brown. Welcome to the Disability Expert Podcast, back after a little hiatus, and we are here today with my associate, Aaron Dalton. How you doing, Aaron?
Doing great. Glad to be back.
Yeah, so I am so excited today. We're going to dive into not a Social Security disability topic today. Today, we're going to talk about what to do when your long-term disability claim, your private long-term disability claim gets denied. So Aaron heads our federal appellate division at Chad Brown Law. He also is the runs our long-term disability practice area group. So let's just start with that. So we've got our client, we get our call, they come through intake. We look at it and say, hey, I think we can help you. What are you talking to them about in understanding the long-term disability process itself to sort of help them work through this denial and moving, their claim got denied. How do we move forward to try to get it approved?
For sure. Well, the first thing is take a look at the denial letter. Most of them are going to be governed by ERISA. ERISA is going to give us sort of a standardized playing field for the appeals process. So most of these we're only going to have 180 days from the date of the denial letter to actually get that appeal sent in.
Okay. So they need to look at the letter that they receive. Typically at this point, they need to be looking at a copy of their actual policy, many times which they've never even seen. They've never even seen their long-term disability policy.
Right. I always joke with clients and say, I'm the guy that reads the fine print. Nobody ever reads the fine print, but you really have to on these LTD claims.
But inside inside that letter typically, or inside the policy, they're going to understand what the deadlines are. In most LTD cases, it's going to be 180 days. But the first thing they got to do is figure out, okay, I got denied. How long do I have to respond, right?
Right.
Okay, so you go through and you're talking to the new client. You say, okay, we got 180 days. And they're like, and one of the questions I know you get asked is, well, they denied me and it said I could appeal to them. So are they making this, are the same people making the decision? Can you sort of walk through this just convoluted way that LTD claims are reviewed?
Sure. And the confusion is, I think, well warranted for clients because, yes, at this stage, when we have the denial letter, the person reviewing our appeal is also going to work for the insurer. So essentially, you've got one department that does the initial case workup. If that ends up being a denial, then it goes to a different department in the same company to do the review.
So the insurance company who is deciding if they're going to pay you looks at their denial and they're the ones that actually do the additional review.
That's exactly right.
Okay, so I'm assuming you get skepticism when you tell people that?
Absolutely we do.
Yeah, so I think one of the things that's important for people to understand, though, is that we do win these cases. In fact, a lot of lawyers win these cases. We win a lot of them. And the reality is while it is the same agents, it is the same insurance company that is reviewing it, or a department within the insurance company that's reviewing it, there really is at some level a separation of that review between sort of the claims representative who sort of starts your case and then maybe the reviewing board. Is that accurate?
Yes, I think that's fair.
Okay, so you got 180 days. The insurance company is reviewing itself. There's one other thing I think people have to understand about this process. It's really important, which is this idea of developing an administrative record. So can you sort of walk people through, so you got your denial, we've got 180 days. Why is it so important what they do in that 180 days in filing that appeal? What's the sort of catch there?
This may be your one and only shot, depending on the policy, to get information into your case record. So if the insurance company reviewing itself decides, hey, we did a great job, we're not changing our minds, then you may have the option to go to federal court. But by the time you're in federal court, all that the federal court looks at is what the insurer had in their claims file. So when we're preparing this 180-day appeal, we're trying to make sure that that file is as well developed as we can get it in case we end up in federal court.
Yeah, so I think one of the things people need to understand is this isn't, you don't have Jack McCoy. This isn't Law and Order. Like, you're not going to go fight the big insurance company and have a big trial. In an LTD case, you file your claim, it gets denied. You develop the administrative record. So we're gonna fill in the gap. We're gonna talk about why cases get denied here in a minute, and how you sort of build the cases. But that is going to be what a federal judge reviews when they're reviewing your case. So the reality is if you don't get the proper evidence, you don't get a proper doctor statement, you don't provide some countervailing evidence to contradict what the insurance company is saying, you're not going to get an opportunity down the road to add that evidence.
That's right.
Yeah. People do misunderstand that.
People absolutely misunderstand that.
I mean,
yes.
and I think nothing frustrates me more when we get a case and it comes in and they did that first appeal on their own, and now they've exhausted their administrative remedies. That's sort of the technical phrase for it.
Yep.
And now we're in federal court or asked to go to federal court, and we're looking at the record and they're going, but they didn't get information from my orthopedic surgeon who gave me a 2-level back fusion 2 years ago because I thought it was only about my, rheumatoid arthritis, right?
Right. And so that's why I think there's a common misconception. A lot of people think the time to get an attorney is when you've exhausted your administrative review and it's time for federal court. No, the time to get an attorney is when you get that initial denial.
Right. Yeah, because that's the only opportunity you're going to have to develop the record. If you don't develop the record, I mean, it's going to be closed, and the odds of you winning that case is going to be nil. In fact, it's probably going to be difficult to even find an attorney to file a claim for you in that situation. Okay. So you have your denial, you understand the process. Let's talk a little bit though about the denials themselves. So I think it helps people, or could help people if they could understand what are sort of the primary reasons that cases get denied. Because we're going to get a denial, we're going to read it, we're going to tear that thing apart just like we tear the policy apart. But let's talk about what are some of the main things that you see in these denials that are given as the rationale or the reason that the case got denied to start with.
So a big one is some version of insufficient evidence. So
Okay.
the insurer will say, well, there's not enough objective findings to support what you put in your application, or maybe it's too soon and you don't have a good diagnosis to explain your symptoms, and so they say, well, we just, there's not enough medical evidence. So that's a big one, of course. The next one that I see a lot is related to pre-existing condition limitations.
Right.
So depending on how the policy is written, if you go out of work within usually 12 months of getting the policy, then the insurer is going to look at your medical records for some period before to see if the health condition that's bringing you out of work was caused or contributed to by a condition you already had when you signed up for the policy.
So in short form, conditions that you had before you had the policy can act as a denial because they don't have to pay you for conditions that you had before you got the policy.
That's right.
Which is very different in the Social Security disability system, which looks at time frames and looks at date last insured and some of those issues, not getting into them. But in the LTD context, your policy is what controls your relationship with that insurer, and in those policies, you're almost always going to have a pre-existing condition limitation. So I think it's important for people to understand, though, just because the insurance claims reviewer says you have a pre-existing condition,
right,
that doesn't mean you actually had a pre-existing condition,
That's
right?
exactly right.
Yeah. So, and then we hit on one of the things you said too. You talk about the lack of objective evidence. I think a lot of times what happens is clients sort of, they talk about their symptoms and they talk about how they feel, but they don't actually realize, well, it's one thing to say that you have nerve pain in your leg. It's another thing to produce a nerve conduction velocity test
Right.
that actually shows that you have diabetic neuropathy. And so, a lot of times I think what we end up doing is sort of saying, okay, well, we believe you, but that evidence never got in front of an examiner to consider, and we've
Right.
got to fill that gap. So we do a lot of sort of gap filling in the evidence. Okay, so let's talk about treating doctor statements. Most LTD cases, you're going to have their treating doctor, whether that be their family doctor or a specialist, depending on the nature of their condition. It might be I don't know, if they have an orthopedic condition, it might be from the orthopedic surgeon, for example. Or if they have a neurological condition, it might be from their neurologist. So talk about issues you see with completing these forms, because they're given a lot of weight by the LTD company, but unfortunately a lot of times like they act like that form wasn't sufficient to pay the case. So what happens with those types of issues?
Yes. So you're absolutely right. LTD companies place huge emphasis on the treating provider forms. Some of them won't even really process a claim without a treating provider form. They'll say, oh, your claim is incomplete because you didn't prove to us that you have a provider that's supportive of your disability claim. But if that treating provider is maybe not sufficiently detailed, if they skip some lines on the form, if the limitations that they say you'd have in a work setting are too vague, it leaves the insurer some wiggle room to have their own medical consultant come in and say, well, this opinion from the treating provider is all well and good, but it's not really backed up by the medical evidence. Or they might have a vocational consultant come in and say, these limitations aren't really that limiting and wouldn't really keep this person from going back to their line of work.
I think one of the things that happens too, and you wouldn't, I think a lot of times the treating doctor doesn't understand how important that form is. And you sort of get a 30-second review of that form with some squiggles and checks, and you have to go back to the doctor and say, hey, this is really important. You really need to give some detail to this. You need to fill out the form correctly. And a lot of times it's just getting the doctor to fill the form out with some due diligence rather than seeing it as just another form they have to fill out.
Yes. One thing the doctors also do that's very helpful when they take the time to fill out the form is point to that objective evidence and say, I'm basing this limitation on the nerve conduction study that we had or the MRI. And when they really start connecting those dots, it makes for a much more solid letter.
And so when you're looking through these denials, we're looking at cases get denied most of the times are related to evidentiary type issues. One of the things, there's two other things I want to hit though, and then you get inconsistent medical records and you get symptoms versus objective evidence. But there's two sort of really, they're not related, but they're things I think people need to understand is LTD policies are typically structured with two different periods of disability. You have the own occupation, which is the job they were doing at the time they became disabled generally. And then you have the any occupation period, which is any job in the national economy, typically where they can earn some set percentage of the income they were making. So just use easy math. If they had a $40,000 job, any occupation period might say they can't perform any job where they can make 80% of their prior earnings. So if they can't find a job making $32,000 a year or more, they're disabled. So I think it's also really important for people to understand a lot of times we don't get called because the initial case gets approved. So talk a little bit about this second level of denial that people get where we sometimes get involved in this any occupation period transition.
So most policies are written to where the any occupation period kicks in 2 years after the disability LTD payments start. So we do get a lot of calls from folks who say, I can't believe that they approved me 2 years ago. It was so easy. And now they're saying that I've gotten better. No, I haven't gotten better. I've gotten worse.
Right.
But really what's going on when we take a look at that denial letter is, okay, we're into the any occupation period now. And they've hired a vocational consultant to come in and say, here's a couple of examples of jobs that would be within that maybe 80% definition of disability that just kicked in.
That's really important though, because a lot of times when you get to the any occupation period, there is vocational expert testimony that's been engaged by the insurance carrier. And so you're going to have to look at providing your own expert testimony to counteract the fact that these jobs actually exist at these income levels in light of what the client's restrictions are. Final issue we see with denials, and there's more, but is this issue of social media and surveillance. Can you talk just a little bit about that?
So one of the first things that we do when a client hires us and we have that 180-day deadline, we're going to request a full copy of the insurer's claims file. And sometimes there's some surprises when we get that claims file in. So you might think it's just, the forms that I filled out and the forms my doctor sent in, maybe some medical records. Sometimes there's some social media surveillance in there where they've hired a private investigator to actually go on, look you up on Facebook, see what you've been posting. Occasionally, there's actually photographs that you didn't post on social media where a private investigator drove to your house and sat across the street and watched you do yard work all day. So requesting that full claims file is very important to actually see what does the insurer have on you.
Right. So it's interesting. The first LTD case I ever did years and years ago, we we somehow got through the any occupation. We're the own occupation. We got to the any occupation, and this I think it was Liberty Mutual. I can't remember. I want to say it was Liberty Mutual. This lady calls me up from Boston, and she's like, I'm like, why are you guys denying this case? And he says, well, your client is a cheer extreme instructor, and we have her on video doing backflips in the gym. Fortunately, we had been very cordial to her all along the process, and she agreed to pay. Like, she ended up paying a couple extra months, but I mean, clearly that was sort of my first eye-opening experience of, wow, this is not only not helpful and very damaging, but I mean, I didn't even really know. It wasn't like our client had told us that. So I think people need to understand that what you see in that letter may not be fully vetted and understood until we get the claims file, which leads me to the last thing I want to talk about. And I know we're short on time, but what you actually need to do and not do when you get an LTD denial. So let's just go through these just sort of real fast. We'll come back, maybe do another episode on this issue, but let's talk about what are some things that you should do immediately upon getting that denial letter.
Well, the first thing that comes to mind is call an attorney.
Yeah, sure. Yeah, sure.
But you need to review.
And even though we are attorneys, and we do have a vested interest in that, I really do think it's the truth.
I really do think it's true.
Sure.
You need to review that denial letter and first off, figure out what are your deadlines. Every policy could be different. This 180 days is a guideline, but you need to know for sure what your hard deadlines are.
Sure.
If you can figure out what evidence might be missing. So sometimes the denial letter will say, we considered records from this date to this date from these 3 providers.
Sure. And
you may realize, oh my goodness, they don't have this hospitalization or some other significant piece of evidence that's missing.
Yeah, I think getting the evidence right, understanding your theory of the case. The other thing I think is really important to do is be prepared. Because of the way the administrative record is closed, you don't actually get a chance to testify in these cases. So I know one of the things that we frequently do is have the client come in and actually do a full affidavit, equivalent almost to a deposition, where we get them to put in writing in a legal document everything that they're saying is bothering them, because that is evidence.
Yes.
And so I think it's important to look at the case, look at the timelines, but also as you're building your case, understand there is objective evidence, but your testimony matters, but this is the only way we can get it in. All right, let's close with this. Tell us a few things not to do.
Oh, wow. Okay. A few things not to do.
Stay off social media.
Stay off social media. Just don't. It's very hard to unring that bell when there's a picture of you doing something that you said you cannot do.
Yeah.
Don't submit a rushed appeal. I've had folks come in and say, I already submitted an appeal, and I know my case is good, so I did it myself. And we look at it, and it was, a 2-sentence, this is wrong, I disagree. And that unfortunately is not going to cut it. So you really need to take your time working on these appeals to make sure that you're getting it right, because this is your one chance to develop that record.
I think the other thing too is important to not do is you have to understand you can't trust the insurance company to go find evidence for you.
Right.
You can't trust them to sort of gloss over issues in the file. I mean, one of the beauties of the LTD claims is when you get your denial, you know why they're saying you're not disabled. And so you can't assume that they're going to draw a link between the evidence you submit and what they have. You need to, instead of assuming that they're going to connect the dots, you've got to build your own strategy, but you also have to be willing to come in and say, you said that the client was not disabled because of X. That is not correct because of XYZ. And so assuming that the insurance company is going to do something favorable to you is really a major misunderstanding about the process, even though they're the ones making the decision. So it feels like it should be non-adversarial, but the reality is it's very adversarial.
Yes.
Very good. That's all the time we got. LTD is it's a practice area that we care deeply about. We help a lot of folks every year. But when you get that denial, there are things you need to do. There are things you don't need to do. But most importantly, understand the process and who you're dealing with so that you can build a case and actually have a chance to get those benefits that in most of the time you or someone else paid for. And just don't give up, because I mean, we win a lot of these cases, and just because that insurance company says you're not disabled, that doesn't make it so. It's all the time we have. Thank you for watching another episode of Disability Expert Podcast. Join us next time when we talk about other issues related to disability. Don't forget to subscribe. Thanks a lot.